I have Mr. Jones back on docket. He did his TRAS.
Jones, which Jones? I don't.
Joshua Jones.
Oh, okay.
The TRAS came back. I think they recommended outpatient treatment. I believe so.
Yes.
The TRAS.
Okay.
They recommended outpatient with 2 open DWIs.
They recommended our location.
Okay, so I'm gonna do it because I told you I would do whatever they do. But if he mucks it up,
All right, pause right here. This is a huge fork in the road. Outpatient treatment sounds lenient, but listen closely. The judge just set a trapdoor. One slip, one violation, and it flips straight to inpatient as a punishment. Judges do this to give defendants a chance, but it's a very short leash. Do you think this kind of second chance actually helps or just delays the inevitable?
he's going into an inpatient. That will be used as a sanction.
Okay. Will you take a year probation?
What do you think, State?
I'm sorry, I don't have.
This is Jones, Joshua Jones. He has 2 open DWIs. Yeah.
I'm sorry, I couldn't find that.
I think 2 years is appropriate so that we know.
Judge, you know what spot that puts me in. We can go to trial and get the same thing.
Okay. On 2? 15 months.
Okay, that's not.
I'll talk to him.
It'll still be under. All
But
right, sounds good.
I don't know. He's gonna get tested off,
Yeah,
you know?
I will.
He's using.
No, I'll be back.
I guess. Judge, I feel the assessment to have been going to physics and move on.
What is the violation?
Alcohol and weed. I have done everything in my power to try to keep you out of custody. You have 2 open DWIs. I was now going to grant the fact that you had negotiated an intensive outpatient treatment. You now are testing positive for alcohol and marijuana while you're on bond for this case. And I have told you repeatedly that you are at no tolerance, Mr. Jones.
I don't do drugs. Period and point blank.
I have here.
Don't say anything. Can I get a copy of the bond violations before we discuss
Is it
it?
impending?
It's in ready for judge.
I don't know why it's not cool.
March 13th, the results were confirmed by the lab for alcohol and THC. Oh, wait. Joshua Dante Jones, right? Joshua Dante Jones?
It just. That's
This has got, I don't know, something's wrong here.
I'm not understanding. I'm not saying.
Something's wrong. Ow. We need to put pretrial services on probation, man.
I'm not.
This is one of the most terrifying moments you'll ever see in a courtroom. Being told you violated bond when you didn't. Notice how fast panic turns into confusion. And here's the key legal takeaway. Clerical errors happen more often than people think. But when you're facing jail time, even a paperwork mistake can feel life-ending. Have you ever seen how fragile justice can be in real time like this?
I mean, it says here, Mr. Jones.
I don't see it in ready for judge.
No, it's wrong. It's wrong. Let me see it. It's wrong. Let me see. Yeah, it's wrong. It's a Joshua Dante.
Okay.
It's the exact same.
Okay.
You're good.
So we're good.
Hey,
It wasn't you. We're good.
that's not you.
Let's go talk again.
Sorry to scare you.
Judge.
Let's go talk.
He's good.
He's not gonna get the bond.
Judge, you stated this was in ready for judge?
Don't worry about it. Don't worry about it.
Who's in the PR?
Was it an error on our end?
I want to apologize for getting mad at you. I had the wrong person, so it wasn't you. So I'm sorry for raising my voice and getting upset with you. And the reason I got so upset was because you have 2 open DWIs. It's serious business. It's not and so if I see someone that has those kind of cases that are open and when they start having more violations, that really tells me that there's a problem, which is not your case. I mean, I haven't seen any violations, which I'm hoping it stays that way. The idea is that you learn something when you get here, so you leave better than you came, because the last thing we want is for you to become a statistic. We have enough of that. We don't want any more. We don't want any more death on our streets. That's exactly what we're trying to prevent. And everything we do now here is to help you and give you the tools to make you better when you go out in the world, so that you think next time, if you do want to get lit, right? If you want to have 32 shots of tequila, 52 joints or whatever it may be, right? That you think before getting into a car. Because God forbid, it's that one mistake that you dig such a hole you never crawl out of. That's the idea, You've worked a great deal here, really, where they're going to dismiss one of your DWIs, you're pleading to the other one. Nevertheless, when an officer pulls you over, the first thing they do, what do you think they do? They look at your record because they want to know who they're dealing with. If they look at your record and they go up to you in the car and they smell alcohol or dope, it's probably not going to go well. So the idea is, if you're going to get lit, if you're going to have that, be like that, take.
Now, this is a judge laying it all out. No theatrics, no threats, just consequences. This is what probation really is. Freedom with strings attached. Miss one test, refuse one breathalyzer, or pick up another DWI, and that deal disappears instantly. The real question is, does tough love like this actually change behavior, or is it just a system covering itself?
Uber. Do you understand? The agreement that you worked out is, like I said, they're going to dismiss one of the DWIs. You're pleading guilty to one of the DWIs, so it will go on your record. You are now entering into an agreement, a plea bargain with the state. The agreement is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. You will do a TRAS with conditions. You have already done the TRAS. The TRAS has recommended intensive outpatient treatment followed by supportive outpatient treatment, which is good. I'm telling you, I thought they were going to order you to do inpatient treatment. That's what I thought they were going to do. So this is great for you because you're not going into lockup. But understand, it's not easy. You have to get it done. If you don't, do you understand? No drugs, no alcohol, no breath test refusal. So if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. Guardian interlock, a $100 one-time donation to Mothers Against Drunk Driving, and 25 hours of community service. I will make you a deal. Your license is now suspended. I had them look it up to see whether you can drive or not. You can't drive now because your license is suspended. It's suspended until 2026 as to what they state saw and looked up. If you get your license back, I will waive that community service for you. I would rather you spend the time to try to get your license back and get liability insurance, car insurance. If you do, I'll take off the 25 hours of community service. You understand? If you fail at this agreement, I will issue a warrant for your arrest. I'm going to bring you back out. We're going to have a talk about whether you violated this probation. If you do, you're looking at 180 days in jail. You understand?
Stop.
The worst possible thing you can do is just take off. If you do, that's an instant warrant. The other worst possible thing, if you pick up another DWI. If you do, I'm just going to lose even more hair. Don't. Really. If you ever have a problem, come back, talk to us. We can always work it out. There's never nothing that we can't work out. Anything can be worked out. You're giving up the right to a trial, right to compel witnesses to testify on behalf, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense of driving while intoxicated? Yes. I'm going to find you guilty. I'm going to follow the agreement. I'm not going to suspend your license. It's already suspended because of the ALR hearing, so don't just start driving until you get it back. Because you don't have a license, we're going to order you to get a portable device. I've been paying for it now while you're on bond for this case. I can't pay for it any further. Reduce his fees, please. The other thing that you need to understand is DWI is big business. There is a $3,000 surcharge that one normally tack onto this. I'm going to take it off now. But from now on, you ever pick up another DWI, that's a second. From now on, it's a minimum of 30 days in jail and a $6,000 surcharge on a second DWI. Do you understand? All right. Good luck, sir. Thanks, Jimmy. You can wait now. Good morning, Ms. Whitaker. Ma'am, you are charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On September 4th, 2024, officers responded to an assault at In-Town Suites located at 9155 Sam Houston Highway in Harris County, Texas. This call was advised that the manager was pepper sprayed by the defendant. The complainant, the manager, was transported to Houston HCA Hospital, and the officer reviewed the lobby security footage. So the defendant approached the complainant, becoming increasingly irate as they conversed. While the defendant was arguing with the complainant, the defendant grabbed a pink-colored pepper spray canister and discharged it at the complainant. The defendant quickly exited the lobby and fled the scene in a red-colored Mercedes-Benz. The complainant told the officers that she was working the front desk when the defendant came in, upset about her reservation, and demanded a refund. The complainant tried to explain to the defendant that she did not have the authority to issue a refund when the defendant pepper sprayed the complainant and ran off. The complainant positively identified the defendant through a photo array.
Okay. Ms. Whitaker, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons, and not to go back to this location. If I find that you violate these conditions, if you become a danger to my community, I only have one place for you. Do you understand, ma'am?
Yes.
I'm not asking for much. Do you mind filing those conditions, please?
Yes, Your Honor.
Do you have the ability to hire a lawyer, ma'am?
No, sir, I'm not working.
Okay, I'll have you fill out an application. I need to know everything about you, how much money you have in the bank, what kind of...
There's no money in the bank.
Whether you drive a Mercedes-Benz, what...
In my daughter's name, she pays for it.
I need to know everything about you, ma'am.
You can know everything.
Deputy Miranda, do you mind giving an application? Do not leave until you sign our bond conditions, ma'am.
Judge, I'm sorry, there was one more. It's an off-docket arraignment. It's there next to you.
Okay.
I have Mr. Spence on your docket. He's present. The reason for the approach is I wanted to ask the court to consider modifying the MOEP or bond conditions for Mr. Spence. The complainant has communicated with the state that they're unopposed to the defendant and the complainant having contact, and that is the condition that we would like amended.
He's doing an online bib class. Does he have it done? Because once it gets done, the case gets dismissed and he's done.
You're absolutely right. This morning, he officially agreed to do the bib.
I have since January he's been working on it.
Well, we were...
Given him more time in February. Now we're March 26th.
There was some communication with the state regarding which bib class to complete. That has been resolved. He's agreed to do it. It's a 16-hour online class.
I'm giving him 2 weeks. You know, really. We're now at 170 days. He doesn't have it done. The offer's been there since January.
I think we're okay with the 2 weeks, Judge. I just don't know how the court feels about amending the bond at this time.
Mr. Spence, come up.
And further background, there are some business transactions, legitimate business transactions between the complainant and the defendant. And they're both respecting the bond conditions and the MOAB, not having contact, but it's interfering with those business transactions, Judge.
Judge, we defer to the court. I will confirm everything defense has said.
Oh, you haven't confirmed it yet.
Well, no, I have confirmed it. I have been in contact with the complainant. She is asking to amend the bond conditions, but we would defer to the court to that ultimate decision.
Okay. Any prior assaultive history against the same complaining witness?
There is a prior assault of the same complainant. It
I'm
was
not going to do it. No, he has a prior assault against this person that's just been dismissed. No. And I'm telling you now, your case is 170 days old. Since January, you've had an offer to have this case dismissed for you doing an online anger management course. You now have 2 weeks to get this thing done. If you don't have it done, I'm going to set your case for trial. Do you understand? Okay?
We'll get it done, Judge.
Thanks.
Thank you, Judge.
Yeah, always a pleasure.
Likewise.
I'll get you. I am reporting on Sierra Mitchell.
Mitchell. Oh, is it a new case?
So, no, what happened was I was her felony appointed lawyer upstairs.
Oh, did it get?
It got dismissed, but they refiled it as a misdemeanor. And so I've already talked to the MAC, and I was going to request from the court that I'll be appointed as her MAC lawyer.
Are you on the list to be appointed?
I am. I'm a MAC lawyer.
Already spoken with Morgan, and she said she was fine as long as she got the green light from you.
I'm okay. Sure.
Okay, I'll make the request.
Yeah.
I'll just need your bar number when we're done.
Thank you for getting on our case.
No, no problem.
But we need to do bond conditions and
Yes,
stuff.
here's the
It's an arraignment setting.
Right. Here's the PSR, and we
Okay.
can follow up.
Ms. Mitchell, come up. Good morning, Ms. Mitchell. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. He has been gracious enough to now sign on to your case. He's doing it. So please.
On April 10th, 2024, the complainant stated that he got into an argument with his roommate, the defendant's boyfriend. The complainant stated the defendant scratched him while his arms were being held bound by the defendant's boyfriend. After, the defendant used her forearm to put the complainant in a chokehold with her knee on the complainant's back. The complainant stated the chokehold lasted around 6 seconds and his breathing was short and it was painful to swallow. The defendant also stated to the complainant, "I'll kill you, ho." The officers observed visible injuries to the complainant's face, chest, arms, back, and shin. The complainant stated that the estimated level of pressure on the neck was a 10 out of 10.
Okay. Ms. Mitchell, do you know of any dope or alcohol, anything of this nature?
No, Judge.
Nothing alleged. No.
Ms. Mitchell, I'm going to find that there's sufficient probable cause to go forward with your case. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. I'm also now granting what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Sims as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this court order, they will file additional cases against you. A violation of protective order is one of the worst cases you can pick up. Because you have a lawyer, I will waive your appearance. But Ms. Mitchell, it is your responsibility to stay in touch with him. If he tells him he cannot get a hold of you because you're playing games, you've gone AWOL, you pick up a new case, you become a danger to my community, it's not going to go well for you. You will not get any more PR bonds. Do you understand?
Yes, sir.
Okay. So she has a prior, okay, the impeding breath is this case now.
Yes, sir.
Do you have any other
No prior, no criminal history, Judge.
All right, I'm going to set your bond at $100 and I'm going to grant you a PR bond today. But like I said, this is the only one. If I find that you become a danger, it's just not going to go well. Do you understand, man? Okay, I'm going to have you sign a reset with Victoria. We'll have you take a seat while we generate your bond conditions. Do not leave until you sign them. And after that, you'll be free to go. Thanks.
Judge.
Mr. Chairman, raise your right hand, Tim, please. Please solemnly swear affirm that you've been convicted of a felony, namely, what's the aggravated robbery? In Texas, for 2000. And that you reflect in the judge, as I was supposed to, and this today.
Hey, Abigail, Abigail,
Yes.
I need you with your computer.
Yes, absolutely. Sure.
See any other DWIs anywhere else, please?
All right. I get a cost number.
It's 253-9108.
Jobs.
In the same one, you send the choose music. Okay. Mr. Dell, can you get your.
Not only that, can you run the license as well?
Just these two for the
Nothing else?
DWIs.
Okay.
And then prior.
And then the license, please.
Oh, the license, yes.
This is from a big building, and this one, is one of the big.
It is suspended for ALR.
Okay.
The end date is
Just say
2026.
the end date is when?
2026.
Okay.
So next February.
Press down.
Oh, and Caroline, we have news for you. Kenzie and I are leaving on Monday.
No, really?
We are sad to go, but
Oh, where are you going?
keep it up.
Okay. Where's she going?
Oh,
You know?
I don't remember.
Really? Awesome.
For my niece something.
One more time.
Is it
Nice.
for my nieces?
So who, do we know we're getting 2 new people?
You're getting one host bar,
Okay.
goal, right near the office. And then, and then you're getting John, he's one of our class, he's pretty good.
Okay, great.
Hold on.
One new, one old. And Blaze is staying. And Chief is
Stays,
staying.
right?
Yes, yeah, so. But new group.
Are you excited?
I am, I think so. I don't know a lot about juvenile, so I'll see how it goes.
It'll be a good learning
I
experience.
think so.
Yeah. Which court are you going to?
42nd.
Wait a second.
Judge Nelson.
Okay, she's smart. She's good.
I've heard I need to be very uncomfortable with it. So.
Just preparedness is everything,
Yes.
you know? Law, you know, because you're not going to get all the, like, you'll get to really see what, you know? It's going to be fun.
My parents say that my job is exciting now. I'm like, wait until next week.
I hope you have a good chief because that really is what makes or breaks your, you know, because a lot of times, and I don't want to know, I don't know if you get to really do what you want to do, what your heart tells you to do, but I hope.
Hey, do you need anything from, Spears, Larson?
Is it?
Okay, you good? You good?
Oh,
Thank you for the judging.
Yeah.
Yeah. And it's been a good argument.
Well,
But we'll be here till
you
Friday.
know, the idea is that it's easygoing, nice, fun, but stern when you need to be, you know? Who's the young lady in back?
Yeah.
Becky?
Okay.
Oh, that guy? Okay, got it. All right, coming up, guys. Mr. Jones.
You gave him members, right?
yes.